Good morning. Welcome along to this webinar, the next in our series. This is on directors' duties and corporate governance, how to protect yourself and your business. So nice topic today, and two presenters covering this very important topic. So I'm delighted to be joined by Lyndsey McSherry and Peter Cashel. Peter's a solicitor within the corporate team at McSherry and is assisted with a range of corporate and commercial transactions, including company reorganisations, acquisition and sale of companies. Lyndsey is an associate within the corporate team also, and also has an extensive range of experience in assisting with corporate and commercial transactions. So delighted to welcome you both along today. Thank you for your time. Just to say, there'll be time for questions at the end, so please do use the Q&A chat function, and as I say, we'll come to those at the end. So happy to hand over to you both, Lyndsey and Peter, if you want to get started.
Super. Well, thank you, Vincent. And this is something that Lyndsey and I have been, I was going to say looking forward to, but probably saying that we're petrified about it would be also a fair comment. But certainly very glad to have the opportunity to go through this. It is an important topic, and it's a topic that's very current at any time, because at any stage, and we'll touch on this later, you'll see different examples of when companies not having the best corporate governance causes issues. So it's good to have this discussion now, so that those listening, if they are involved in companies, can consider maybe implementing some of the steps that we touched on. And I'll just hand over to Lyndsey briefly just to introduce, so she can introduce herself.
Yeah, so as explained by Vincent, I'm an associate in the McSherry corporate team. I've been here for about 2.5 years now. And yeah, I deal day to day with these issues. So I'm also happy to have the opportunity to speak to you on it. In today's webinar, we are going to go over good corporate governance, directors' duties, some of the issues that directors might come up against. We'll then go into some of the steps to follow that should hopefully mitigate against having to encounter these issues. And then finally, we're going to have a little review of recent changes in the corporate law sphere that directors should be aware of, together with some future changes just to keep on your radar going forward.
Thanks, Lyndsey. And just a brief spiel about McSherry. So we're a local independent law firm. That's something we're quite proud about. And we have a 360 approach. And what that means is that we can cater for all your business needs. We have that resource and capacity within the firm, whether or not that's strictly corporate or commercial, or if it delves into property matters that affect the business, and also then succession planning for shareholders if they're looking to exit as well. So corporate governance, what do we mean whenever we say corporate governance? What is that getting into? So corporate governance is a combination of the rules, laws, processes that affect how a company operates, and it encompasses internal and external factors, including the company's stakeholders, as well as the shareholders and customers. And good corporate governance will ensure that the board of directors meet regularly, that good records are kept whenever they do meet, so that there's some accountability, and that the board of directors retain an element of control and oversight of the company. And that's important because it feeds into the operation of the company and how effective and efficient it can be. It gives confidence to a company then whenever it is efficient and whenever it has certainty in terms of how decisions are being made. And it can also signal to the outside world looking in that the company is in good standing. And that may be from an investment point of view, people you're trying to bring on board. Banking, if you're looking for finance, it can be a good signal to lenders and make them comfortable. And then also with suppliers and customers, if good corporate governance track record is there, it can give confidence to them to engage with the company. So it's good practice, and the benefits of it flow with that in terms of how you're able to deal with third parties. And effectively, yes, that is a summary of that in terms of processes being efficient, that visibility, giving confidence to internal as well as external parties, and it having a reduced cost and smoother running operations piece as well, because there is that certainty of how decisions are made. Now, the structure of a company, I'm sure you're very familiar with it, but this is just a quick piece, because we'll be touching on shareholders, directors as we go through this. So the shareholders of a company are effectively the company's financial supporters. They've purchased shares, they've put money into the company, and by purchasing those shares, they are, of course, shareholders and part owners of the company. Now, the board of directors oversee the management of the company's business, and typically they have a view on increasing the company's value. That's traditionally, generally, that's what people would deal a company being successful if its value is increased. And if I can use the analogy of the bus, where the shareholders are the passengers in the bus, and the board of directors are effectively the bus driver. So the shareholders are sitting back saying, this is where we want to get to, and the board of directors are there to decide how they get there. And it's important that board of directors therefore have an element of free rein and flexibility to be able to decide how the business operates on a day-to-day basis. Now, having said that out, the directors do have responsibilities, because after all, they are driving the bus and they can't take it anywhere. So there has to be some accountability, there has to be some check on their duties to those shareholders, especially given that those shareholders are the financial supporters of the company and have put money into it. So under the Companies Act, there are certain general duties to the company that directors must give. They must act within their powers in accordance with the company's constitution. And whenever I talk about the company's constitution, I'm talking about the articles of association that the company have that are available publicly on Companies House. And they must act in compliance with any written resolutions that shareholders pass, or any shareholder agreements or joint venture agreements as well. So there is a check on the power of the director. They don't have absolute free rein, and they must act within that power. It goes without saying that, as I just touched on, the company or the directors must act in a manner which promotes the success of the company. And as I said, success generally means over the long term increasing the value of the company. But it is up to each director fundamentally to decide whether it is appropriate for the company to take a particular course of action. And when deciding if action will promote the success of the company, the directors must have regard to that list that you see there before you, and that touches on the long-term implications, consequences of their actions, but then also having reference to stakeholders of the company as well. And that includes, as you see there, parties that are very closely connected to the company, which of course that makes sense, the employees, and those parties the company has commercial relations with in terms of suppliers, customers. But also you'll see it touches on the directors having regard to the community and the environment as well. So that may be how their actions will affect the local community. That could be the people in the town, or that could be regional as well. This is not an exhaustive list, but it is designed to highlight areas of particular importance whenever business directors are deciding what course of action to take. Directors must exercise independent judgment, albeit that judgment must be within the confines of any agreements that they have or their constitution as well, so that they don't, whenever they're exercising that independent judgment, it must comply with the company's rules under the Articles of Association. And in exercising that independent judgment, they must take reasonable care, skill, and diligence. And the standard of that is it's both objective and subjective. So a director's actual understanding and abilities may not be enough. The expectation of a director's understanding and abilities may not be enough. If you could reasonably expect more from someone in their position. So the standard that an accountant, a director with an accountancy background on financial matters will be higher than the standard expected of a director who deals with commercial contracts within a company, within the board, on matters that involve finance. Of course, it goes without saying, directors must avoid a conflict of interest, so they must avoid a situation in which they have or could have an interest on a particular matter. This applies particularly in relation to the exploitation of any property, information, or opportunity. Not to be doing an insider trading line, although this duty is not infringed if the situation can reasonably be regarded as likely. The situation cannot reasonably be regarded as likely to give rise to a conflict of interest, or if the matter has been authorised by the directors. Now, it can be a difficult one. Where's the line on a conflict of interest, and if it arises, or whether or not it arises. So if you think there is a potential conflict of interest, to resolve that, you should seek approval from the board of directors. And at the start of every meeting, the chairman will typically set out what the business of the meeting is. So there should be an awareness of what will be discussed, and at that point then directors can set out any conflict of interest they may have. If the directors do not have the power to authorise the conflict, then seek approval from the shareholders, and also check the Articles of Association, the rules of the company, to see if they contain any provisions relating to conflicts of interest. Following on from that, and tied to that, directors are not to accept third-party benefits from third parties for obvious reasons. Although hospitality provided by third parties is acceptable. So don't worry about those little trinkets that you may have got at Christmas or whenever you go and visit another company, if it's hospitality related. Following on from that, and again this ties in closely, it's on that theme of conflicts of interest. Directors must declare any proposed or existing transactions or arrangements if they have an interest, whether or not that's direct or indirect. Now, in the case of a proposed transaction, of course, you can declare that interest prior to the transaction being actioned or taking place. And in the case of existing transactions, you must declare that interest as soon as possible. And as I noted there, you'll have an opportunity to do that whenever the board meeting takes place. Now, there are other other duties that apply to a director which are not noted within the Companies Act. So a director owes a duty of care to their company, not to disclose any confidential information for obvious reasons. And there's also an obligation on directors to operate the company in a way that complies with health and safety legislation and legislation related to the welfare of their workers. And obligations arise under environment and anti-corruption legislation too. So it's worthwhile to have that in mind, that the duties go beyond just what you would see in the Companies Act. Now, just to touch on, I suppose, the issues that can arise from those duties. So corporate governance can directly impact the profits and reputation of the company, depending on how it's done. So PER policies can expose the company to lawsuits, fines, reputational damage, and loss of capital and investment. And it's worth noting that even if the financial implications of perhaps a PER policy or PER corporate governance isn't realised, or if directors are not disqualified, the reputational damage can be long-lasting. And with that, of course, any goodwill that's been built up can be diminished all too quickly. I've just noted a couple of examples there. No doubt Carillion will ring in that bell will ring in the head. That construction giant that was wound up in January 2018, and the fallout of that was the Financial Conduct Authority doing a review and finding that the true financial position remained hidden, distorted, and aggravated the local market and caused harm to the shareholders and the creditors. And in that instance, actually, the Insolvency Authority had attempted to disqualify non-executive directors, and which ultimately was withdrawn. But it's worth noting that even non-executive directors, in certain circumstances, can be followed through. And we'll touch on that later whenever we get to shadow directors. And then in relation to P&O ferries, there was that notable headline fallout following the redundancy of 800 employees, and that was done without notice. And they ought to have been given notice, but they were not, and there were calls for directors to resign in that instance as well. And ultimately, in relation to P&O ferries, there were no resignations, but the reputational damage was done in that instance. So, touching on conflict of interest earlier, and on the duties piece, conflict of interest occurs when an officer, director, has financial interests that directly conflict with the objectives of the company. That can be realised whenever it comes to perhaps contracts that you're dealing within the company. If a director is a shareholder of another company, which you may be doing entering into a contract with, or considering whether to enter into a contract with, because of course they may have a vested interest in the company entering into that contract. When these conflicts of interest are present, they can deteriorate the trust of shareholders, naturally, and the other stakeholders, while making the company vulnerable to litigation. Because it's questionable whether or not a director may have been acting to promote the success of the company that they are a director of, or that they are a director of, or if they were acting for their own interests on matters. And to avoid whether or not you have good policies, it's important that they're implemented well. So a policy is only as good as its implementation. So directors must have substantial oversight on companies' practices, and that oversight encompasses executive staff, those senior staff members that may be actioning the company's policy. And by having oversight of those senior executive staff, it means that the company should be, the directors ought to be more aware of the daily operations of the company, in order that they can ensure that the objectives are being achieved. And without that oversight, so it's important that policies are implemented, but without that oversight, staff may violate laws or cut corners or not make, and that could make the company vulnerable to third-party claims, fines from regulatory agencies, and again suffer that reputational damage. So it's critical that that oversight is in place. And then again, accountability, it's very important. Otherwise, somebody could go on a frolic of their own. And so there should be a level and division in the company that reports and is accountable to another, so that there are good checks and balances in place. Above all else, the actions of each level of the company is accountable to the shareholders and the public. And without accountability, as I said, one division of the company might endanger the success of the entire company or cause stockholders to lose the desire to continue their investment or to continue their engagement with the company. Now, transparency is important, and companies must accurately report their profits and losses and make those figures available to those who invest in the company. Over-inflating profits or minimizing losses can seriously damage the company's relationship with stockholders, in that they are enticed to invest under false pretenses. And a lack of transparency can also expose the company to fines from regulatory agencies. And we see that with Carillion there, in terms of their reporting and what the Financial Conduct Authority had to say on that. So it's important to keep up to date company house filings so that that transparency is in place. And on the accounts, the issues that can arise in terms of those violations, there is a duty of care to exercise care, skill, and diligence in providing those accounts. And it's easy to demonstrate that a company's been run well whenever it's prosperous and it's financially stable. It's a different story whenever the company's finances are not operating as well as the directors would like. Some of the key issues for director of a company which is insolvent or approaching insolvency are modification of the general duty to promote the success of the company, as that can also apply to creditors as well as the shareholders, making sure that they are able to pay creditors. The director can be ordered by the court to continue contribute towards the pool of assets which are available, to the company's creditors, where they ought to have concluded that there was no reasonable prospect of the company avoiding insolvent liquidation or administration, or continuing to allow the company to trade or alter how it trades. So if you're a director and the company is going south, and it's going south very quickly, and there's no prospect of return, at that point you have to act in the interest of the creditors to ensure that no further debt is lumped on, and to leave the company in a position that it can discharge any debt owed to creditors. And a director does not have to be dishonest to be liable for wrong trading. They cannot avoid responsibility by resigning from the company when potential difficulties are spotted. Again, with Carillion, that was the case with one of the directors who had resigned prior to investigation. They were still caught up on that. So it can be a thorny issue, because once you're in that storm, there is a duty to see it through to the best of your ability. And in terms of, just to touch on fraudulent dealing and misfeasance, fraudulent trading involves a degree of dishonesty on the part of a director, as the offence requires an intention to defraud the company's creditors or some other fraudulent purpose. And again, a director may be required to contribute to the company's assets available for distribution to creditors, or face criminal proceedings. On misfeasance, a director can be guilty of this if they have misapplied or retained company assets or wrongfully exercised authority. It does not necessarily involve a moral blame. And a director in breach may be ordered by the court to repay money or contribute again to the company's assets available for distribution to its creditors. Now, I touched on non-execs, shadow directors, de facto directors earlier with Carillion, and it's an aspect that of a company that can float on in the background and maybe not be discussed that much. Appointed directors of a company have certain statutory duties, which we discussed earlier, and they are to abide by and can be held liable for their conduct in the day-to-day running of a business. However, in certain circumstances, those individuals involved in a company's business who are not statutory directors can also be found liable for breach of director's duties without being formally appointed as a director. And whenever we talk about those individuals, we're talking about shadow directors, de facto directors. So a shadow director is a person or corporate body which, although may not officially be appointed to the board of directors, controls or influences the management of the company by making decisions behind the scenes. De facto director, those individuals who behave as and are understood to be directors in practice and not being formally appointed. So in those cases, that might be somebody who's listed on the letterhead of a company as a director, or on company business card as director, or other company stationery, they hold themselves out to be a director. It is important for those in management roles or senior positions within a business to minimise the risk of being considered a shadow or de facto director, to avoid any potential liability for conduct which may not be in keeping with the duties and responsibilities imposed on directors. This is a particular concern where the company is experiencing financial difficulties, and the actions of the board and other senior personnel will be subject to closer scrutiny. And again, harking back to Carillion, but it is just such a good example of that, because the insolvency authorities sought to disqualify non-executive directors in that instance. So now that I have discussed the duties of directors and the issues that can arise from that, I'm going to hand over to Lyndsey to run through good steps that you can follow to mitigate those issues. So Lyndsey, over to you.
Thank you, Peter. That was great. It was really informative. Thank you. So as Peter's worked through the issues now, I'm just going to take us through some steps that we would suggest that directors and companies follow in an aim to mitigate against these risks. And the first one would be having good articles of association in place. So under the Companies Act 2006, all companies must have articles of association. There are internal arrangements, or essentially the rulebook of the company, and they'll be filed on Companies House and made publicly available to view. The articles deal with shares and memberships, directors, meetings, and the alteration of the articles themselves. And all of the company's directors should familiarise themselves with the company's articles of association and any applicable shareholders agreement, most particularly the provisions that deal with the decision making and conflicts of interest, as Peter has touched on. So essentially the decision making provisions that directors should pay particular attention to is in around board meetings, how and when they should be called, how many board meetings are required a year to be held, the quorum provisions, who needs to be there, who's entitled to vote on the matter, as we're through with Peter, conflict provisions. Do conflicts have to be immediately declared? Can they be authorised by the shareholders? Can the director go ahead and vote even if they is conflicted? And then how decisions are made. Are decisions made on a majority basis or on a unanimous basis? I think it's really important to flag from us that if you are a director, you really should be taking proper legal advice to make sure that you have a good set of articles drafted. We tend to find a lot in Northern Ireland, some companies will go ahead and incorporate with model articles, and they never get round to actually drafting up a good set of bespoke articles that are really tailored to your company. And whilst model articles are great and they're meant to be the blanket and they cover everything, they do have their pitfalls. For example, if you are a sole director company, the model articles don't actually cover your decision making. Essentially, under the model articles, you need to have two directors, they have a core meeting, and for any decision to be passed. And obviously, a sole director company isn't going to have that. So that's one of the very first things we would change when we're looking at articles for a company. Secondly, the director's conflict provisions. Article 14 of the model articles sets out a director actually can't be voted or can't be counted in a vote, when they are conflicted in matters. Once again, that's something that we would pick up and change. And then there's also no provision to appoint an alternate director. I know in smaller companies this might not be as big of an issue, but the ability to appoint a director can sometimes be really useful. For example, last week we sold a company and the two selling shareholders, only one of them is going to remain on the board going forward post-sale. And basically he's put an agreement in place for the buyers of the company to say that basically the other seller, should he go on holiday, he can step in for him, so that they still have an interest going. They have retained some shares in the company, and it's just to ensure that their voices are heard and the interests going forward. And around the point of articles, and obviously more generally on good governance, we would really stress the point of record keeping, meaning board minutes. Obviously, it's not something that it's something that we don't see basically very often in NI companies. We think our counterparts across the water are much better at doing up board minutes and having records of decisions being kept and whatever. But really, the point to flag is that if you do come to a doomsday scenario and we're in an insolvency situation, the directors are going to want the note of the decisions that they've taken or maybe haven't taken in that scenario. And it doesn't have to have, like, your minute doesn't have to have all the whistles and bells that you might see when we draft up a minute. Essentially, have a note of who's there, is the quorum met, what's the business of the meeting going to be, is there any interests, and then any decisions that we're actually taking, just have a good note of them. And then moving on, also obviously in the sphere and about good governance would be a shareholders agreement. So obviously everyone here is going to know what a shareholders agreement is, but we'll just give a little reminder. Shareholders agreement is a contract entered into between all the shareholders of a company and normally the company itself. It governs the relationship between the parties and includes personal rights and obligations of the shareholders. The shareholder agreement is pivotal in protecting the interests of the shareholders and enables the shareholders to have more input and control over the board of directors. Together with the Articles of Association and the Companies Act, shareholders agreement, this will form the rules and requirements by which the company, the directors and the shareholders are required to act in relation to each other. So obviously, whilst the name suggests shareholder agreement is aimed more at the shareholders, if you're a director of a company, it's still really important that you have sight of the shareholder agreement because it deals with similar provisions to the articles. Peter, if we can just flick on to the next slide, please. So the shareholder agreement will also, amongst other things, will deal with the appointment of directors, decision making by the company and related consent mechanisms and vetoes. So essentially that is where you may have consent matters, so basically reserve matters are only to be taken at shareholder level, and will also be then a list of matters that directors can go ahead and they can take without that they have the ability to take those decisions. But then there's going to be matters then that the actual owners of the company would rather they have the final say on, and essentially it's a veto over the directors that on certain matters that's what the shareholders say go, it's not the directors. There's also restrictions on the issue and transfer of shares, withdrawal from company, restrictive covenants for shareholders, and then dividend policies. Dividend policies in particular is something that the directors should make a note of. Obviously, whilst dividends are paid out to the shareholders, it's actually the directors who declare the dividends, taking into account the entire financial health of the company. So it's important that the directors know basically when they're able to declare a dividend. You might also find that whilst shareholders agreement and articles should mirror each other, they don't. Sometimes the shareholders agreement may go further than articles of association. Essentially, because your shareholders agreement is a private agreement, there might be more sensitive commercial matters dealt with in that, which you wouldn't want to be putting on Companies House to be viewed by everyone in your articles of association. And we would always be including provisions that say that your shareholders agreement, if there's ever a conflict with your shareholders agreement and your article of association, that the shareholder agreement prevails. And particularly dividends could be one of them. You might have very general wording on your dividend policy in your articles, but then there could be very bespoke, no dividends to be declared until a certain funder is paid off or whatever would be in your shareholders agreement. And they're the type of things that directors need to know before they would declare a dividend. And then the next one would be third party and professional advice. So some boards might have the luxury of ensuring they make specific provision to ensure that the makeup of their board covers a wide range of professional practice areas such as lawyers, accountants, someone who's skilled at HR advice. But it won't be every company that's able to do that, and not every company will have members of the board that have the necessary training and skills or experience to cover every area of risk. In this case, we'd be suggesting that the board of directors can circumvent a lot of potential problems by ensuring that they in turn then take appropriate professional legal advice, including legal, aka come to us, accountancy and audit advice, insurance advice, and HR and general risk management and compliance. And we'll come on to the general risk management and compliance a wee bit more later and how important that actually is and the themes that we're seeing. Yep, thank you, Peter. Other steps that we can take are getting directors and officers insurance in place. Basically, directors and officer insurance policies are becoming more and more common. These are insurance policies that offer cover for protectors, protect them personally from claims which may arise from the decisions and actions taken within the scope of their regular duties. Directors and officer insurance can be paid for by the company and can just offer that wee bit of confidence and support to directors in carrying out the role, knowing that there's a bit of a fallback there for them. Also, we would say it's really important to have director service agreements in place. You're amazed how many times that statutory directors at the company are just operating without any terms, apart from they know how much they're getting paid every month and with their hours of work, but there's no formal service agreement there. A properly drafted director service agreement is really advisable because it's going to protect you as the director and also the company, and it's just going to set out really clearly what everybody's rights, roles and obligations are. So we would really strongly suggest that they are put in place. So that is the steps that we would suggest that might help towards avoiding the issues that Peter set forth. Obviously, if you want any further advice on that, feel free to reach out to us. And then our final little section we're going to do is on recent and future changes in legislation that we think would be helpful to directors to be alive to. So one of the most prominent recent changes, I should say, is GDPR. It seems to be all we're hearing at the minute. And I appreciate that whilst construction companies aren't maybe dealing with huge volumes of personal data every day in terms of your customers, you still have obligations to your employees dealing with their personal data. So it's so important to stay alive to GDPR requirements. So basically, GDPR, the European General Data Protection Regulations, came into force in the UK in May 2018. However, since the UK left the European Union and the transition period ended on the 31st of December 2020, the GDPR has now been incorporated in the Data Protection Act. That was when all our inboxes were flooded with all the emails from every single website that we've ever signed up to asking that we only opt in or opt out of their marketing. The legislation aims to give citizens and residents more control of their personal data. Basically, everyone has a right to find out what information the government and organisations hold about them. And the regulations also aim to simplify for all businesses to help them protect against personal data and making sure that information is used lawfully, fairly and transparently. So essentially, what information are you holding? Why are you holding it? How long can you hold it for? So on and so forth, and the various policies you need to have. And then it's not just a matter also, we would say, of processing data, but we're also seeing how that sits side by side with cyber security and security of personal data being held, and notification requirements to individuals, or if needs be, the information commissioner, if you do have a security breach within your system, and any data is accidentally leaked or breached because due to that. It's an issue that we're seeing more and more often. We can get to the next slide, please, Peter. So staying on the topic of GDPR, as I said, data protection issues are becoming more and more prevalent. We are seeing more and more funders and buyers are raising more queries around GDPR, companies, policies and practices in relation to GDPR. We're actually seeing it more often not becoming a bit of an indemnity issue, and we've got into a fair few legal battles over it, I'd say, in the past few months. And that is because we're seeing increasing trends in the ICO of, whilst traditionally it was always the big fish that the ICO was looking at, and they were the only people that they were picking up on and issuing any form of enforcement notices to. There's actually now been a few smaller businesses and sole traders that have had enforcement notices issued to them. Now, at the minute, from what I can see, this mainly seems to be around marketing and to do with marketing materials and whether you have consent to issue the marketing materials. So I'm not sure how relevant that is to the attendees today, but it might be something to think about if you do issue marketing material. And then another recent change is corporate social responsibility. It's become pretty major in recent years. Society as a whole has become increasingly concerned and proactive on matters of social importance such as race, gender equality, the environment, poverty, mental health. Therefore, in turn, businesses have also had to become more focused on aligning their own interests with this, and have subsequently been ramping up their focus on the same issues, whether it's championing women's rights, protecting the environment, and attempting to obliterate poverty on local, national, or global scales. Not only is having, so basically, good corporate social responsibility, having good corporate social policies in place, basically, for your company is really good reputationally, but also it boosts employee morale, boosts the company image and your brand, and boosts collegiate productivity. Basically, the idea is to make companies more well-rounded and an attractive place to work for people, and it's to give, and also the idea behind it is that companies just aren't purely focused on profit, is that they're also focused on the more holistic approach to their values and that sort of thing. And that leads us on to the next point, which is in a similar vein, which is environmental, social, and governance considerations. Ties in with corporate social responsibility a lot, but the growing importance of ESG considerations for companies has been evidenced in the past few years massively, but just from what the government's doing, and there's been huge legislative reforms. It's become a huge topic in recent years, and even in transactions, we're actually starting to see now, whether it be a funder or a buyer, sometimes we're seeing specific ESG questionnaires being issued that sit alongside your normal DD questionnaires. People becoming that interested in what the company's doing outside of just from a purely profit sphere. The aim is to highlight that directors should have regard to all the relevant factors when considering their duties to the company, and particularly their duty in promoting the success of the company. It's once again, we're not just looking at the financial success of the company, but also the overall success in terms of environment, social, all those types of things. At the minute, there isn't one cohesive piece of legislation in the UK that sets out exactly what ESG law or regulations there are. But as I noted a wee second ago there, it's the various legislative reforms that contain ESG regulations that show the big push towards this. So some of them are the Modern Slavery Act 2015, Gender Pay Gap Regulations 2017, and the company's Strategic Report Climate-Related Financial Disclosure Regulations 2022. And that's an absolute mouthful. I'm not even going to continue that, but you get the gist. That's one of, I think, a couple climate-related legislations that put on the books recently, and we've seen there's a major push towards climate and green energy across the business world. If you look at even TransLink and Foyle, all the metro buses have become electric now. You just see across the board that green consideration is becoming a real major thing, and this is obviously as a result of the ESG considerations that companies are being asked to take. Next slide, please, Peter. Okay, another recent change is anti-money laundering. Basically, this is tighter legislation around anti-money laundering, which brings in more stringent responsibility placed on the companies, ensuring they take the necessary steps to prevent their company being used for money laundering purposes. For us, it's become a real point of focus, obviously in the business that we do for banks, for any financial institution, accountants. It's all really, really relevant. Although it is something that we're seeing will likely trickle down just across the whole business sphere, just to keep alive the funds coming into the business and who you're accepting them from. For us, it's basically asking clients for photographic ID, proof of address, proof of bank account, and that is not just for new clients, but even existing clients. Basically, we have to update our ID documents every 2 years, and if a client comes to us and they're purchasing a property or purchasing a business, even if they've been an existing client for years, we're still going to ask them for proof of funds to make sure that everything's on the books and coming through properly. Moving on to some future changes that we're likely to see. A major one coming up this year is changes to Companies House and the filing requirements. So in the course of 2024, company directors and also company secretaries of every UK company and their advisors, aka us lawyers, we're going to need to start preparing for a wide range of significant changes to Companies House. Basically, there's going to be new company house powers that are now on statute books, which aim to stop companies being used to aid money laundering, which just feeds into what I've just discussed. Corruption, fraud, identity theft, and other economic crime. So I think this just reinforces the idea that there's going to be a real push towards having anti-money laundering protections in place, essentially. So amongst various other changes at Companies House, some of the things that are being introduced are there's going to be new obligations to verify the identities of new and existing directors. There's going to be new restrictions on individuals permitted to file information at Companies House. So essentially that's, we quite often do filings for companies, accountants will do filings for companies. I think there's no clear guidance on what it's going to look like yet, but I think that there's going to be a process of the company directors or shareholders having to confirm who is allowed to make filings for the company, and it's not going to be just a matter of logging onto web filings, having the code and being able to file whatever's needed. And then there's also going to be a restriction on the use of corporate directors unless every director of the corporate director is the human being. So of course this is then to stop companies having shelves upon shelves of corporate director upon corporate director upon corporate director, as that's seen as a bit of a red flag in terms of money laundering, because there's no actual person you can pin any decisions being taken on. And then the last point for us is, so the draft Better Business Act. This has been on the books for quite some time. It's basically the BBA coalition. They're basically focused on changing the director's duties set out in section 173 of the Companies Act from being a duty to promote the success of the company to being a duty to advance the purpose of the company. This obviously ties into everything we've just spoken about on corporate social responsibility and your ESG considerations. So you can see there's this message across the board is really being pushed that it's not just solely financial interest of the company we need to consider anymore, it's a holistic approach. The Better Business Act campaign basically wants 4 principles to be reflected in their amendment. So that is ensuring the interests of shareholders are advanced alongside wider society and the environment, empowering directors to exercise their judgment and weighing up and advancing the interests of all the stakeholders. Default change, they want the default change to apply to all companies, and then they want the requirement of businesses to report on how they balance people, planet and profit in a strategic or impact report, where one is currently required. The BBA campaign has proposed a revision to that section of the Company Act. As I said, this is still on the books, although the 26th of April last year, there was a parliamentary reception on this. So it might be now in 2024 that we see something finally put formally on the books on this. And if we do, then we'll of course keep you updated on it. And I think that is us. Yeah.
Thank you, Lyndsey. Thanks, Peter. That was great. You covered a lot of ground there and lots of changes to be aware of there and cognizant of going forward, definitely. We've got time just maybe for one question or two. We do have one or two that have come in. It's kind of topical one here really around the post office. I think you've probably touched on that and the issues there. Obviously the reputational damage was huge. Is that catered for within statute in terms of the senior personnel there? Would they be sort of at risk there is really the question?
I think.
Yeah,
I haven't watched Mr. Bates in the post office yet, so I'm not as up on this as it should be. But I suppose it depends what we mean by senior personnel and who were the people in the decisions here. It'll probably turn on the facts a lot.
Yeah.
But I think, Peter, you're probably better take this question considering what you discussed. But
So yeah, I mean, with the post office and that issue going forward there, there will be scrutiny from regulatory agencies in terms of how decisions were made, what information was available, on what basis decisions were made by directors. Lyndsey's right, it will turn on the facts. And so, of course, without being brilliantly privy to the facts, because I too have not watched ITV's Cracker series, it's something that perhaps I should, but not being privy to the facts, obviously can't touch on the decision-making process that the directors went through and the information they were privy to. But in terms of process, that will be the process. Regulatory bodies will review that parliamentary inquiries ongoing, and it'll be interesting to see what statement is issued once it has completed. And I suspect, if given how high profile this case has been, if directors have acted in a manner beyond their powers, or if they have not had regard to their statutory duties, then they could be liable to disqualifications, fines, but whether or not they will be is another question entirely. If you look at P&O ferries that I highlighted, there were calls from members of Parliament for director resignations in that instance. Very high profile, but again, nothing actually was forthcoming on that. There were no disqualification orders placed on directors. With Carillion, there actually were disqualification orders placed on a number of directors ranging from 8 to 12.5 years. So could we see something similar with the Post Office? Potentially. And of course, it doesn't matter if you have since resigned as director. There can be look back on that too. Your actions as at the time will still be reviewed, and you could be disqualified as a director.
Right. Okay. Certainly interesting to see what happens there in the future. Definitely another example of potentially anyway. But I think that's us out of time there. So that was full hour. So that's great. Thank you again, Lyndsey and Peter. That was great. And thanks to Bill Sturridge as well for their guidance on this. So I'll draw it to a close there. Thank you.
Super.
Thanks. Bye bye.